to my YouTube channel. My name is Rusima Ngobeni, the legal connoisseur, here to make legal knowledge both comprehensible and within your reach. I am popularly known as Becoming Advocate Ngobeni on Instagram and TikTok, so please do head over there to give me a follow. And then after that, before we start with anything, please kindly follow this YouTube channel. It is going to be basically your legal knowledge hub. Okay, so if you are a YouTube person and you're studying law, this will be the place for you to go get a little bit of tutorials and a little bit of legal related information. It is the first episode of 30 episodes of the Law of Civil Procedure, and before we get into the tutorial, I'd like you guys to know that this is the book that I am using for the tutorials. It is The Fundamental Principles of Civil Procedure. It is the 4th edition and it is by C. Theophilus, who's a volume editor. Then it's C.M. van Heerden and A. Boroyan, I don't know how to pronounce the surname, apologies if I'm butchering it, and A. Ruin. So these are basically the compilers of this textbook here. I used it while I was a Wits law student, and I'm also still using it as a pupil advocate at the GSA. So honestly speaking, it is quite helpful. Additionally, I will be using the Uniform Court of Rules Erasmus, but that will be for the other tutorials that we are going to host. So today, since it is an introduction, the things that I basically want you to know at the end of the tutorial is what is the law of civil procedure and what is the difference between civil procedure and criminal procedure. You should also know the underlying principles of the law of civil procedure as well as the sources of the law of civil procedure. Just 4 things. That's all you have to understand with this first tutorials. And then after on, the second episode will be jurisdiction. There is going to be a lot for you to know. So with this one, we're just easing you into things, and then after that we are going to get into the crunch of things. Let's start with the tutorial. What is the law of civil procedure? So in South African law, there is a distinction between substantive law and procedural law. So what substantive law is that it describes a person's rights, duties, and remedies in a particular situation. And then procedural law, of which the law of civil procedure is a part of, indicates how those rights, remedies, and duties may be enforced. So essentially, what it does is that it allows a party or enables a party to approach the court for legal relief for any infringement of that person's right? So if you think about it, I would say that it furnishes mechanisms for the enforcement of the substantive law. Then we move on to what is the difference between criminal procedure and civil procedure. So civil procedure has to do with civil law, and if you're wondering what civil law is, it is your things like your family law, your law of delict, your law of contract, your insolvency law, your insurance law, and things like that. And then criminal law would mainly be things or offenses that you do that would make you criminally liable for a charge. But let's get straight into it. So civil law and criminal procedure enables parties to take actions to enforce their rights and claim remedies or to defend actions that are brought against them. So it is me and you, ordinary civilians, having a charge or a claim against one another, or A and B are married and B no longer wants to be married to A. So what they do is that they then institute a proceedings, which is going to be a divorce proceeding. So that is what civil procedure is. And then when we are now moving on to criminal procedure basically enables the state on behalf of the general public to take actions against people who infringes on the laws of the rules or the laws that are found in the Criminal Law Act, or the laws that are deemed to be an offense. So what does that mean? That basically means that you are charged by the state. So it is not between you and I if you happen to commit murder, yes, you murdered that person, but the state is the one that is charging you because they are protecting the general public from you committing such acts. So acts that are deemed as illegal in the criminal procedure and in criminal law would then have you being criminally liable and being criminally charged by the state. And the objective of criminal law and criminal procedure is to basically punish wrongdoers and to ensure that society is a safe and law-abiding place for everyone that lives in it. So South Africa in this instance. So that is what the difference is between criminal procedure and civil procedure. Then we now move on to the underlying principles of civil procedure. There are quite a lot, so I will try to move as fast as I can, okay, because also it is an introduction, so I don't want it to be extremely long. So the first one is that all persons must have equal and effective access to a independent and impartial judiciary. So this means that the presiding officer has to be impartial and independent. So in some instances, you do find that the judicial officer may, or the presiding officer does know one of the parties. So then in that case, they're not really independent and they're not really impartial, because if the presiding officer is my grandfather and I'm bringing a case before him, or is a relative of mine and I'm bringing a case before him, would you really say that judicial officer or that presiding officer is impartial and independent? I don't think so. So basically this is what this principle talks to or addresses. And then it also says in the second one that throughout the proceedings, parties must be afforded equal opportunity to present their respective cases to court. And if you think about it, this is in line with the ad audipartem principle, the Latin term. So those that it's audipartem principle. Oh, guys, I struggle with Latin, but basically this principle then ensures that the defendant will be notified that there is a proceeding, and both parties will also be notified, and the defendant will be given an opportunity to basically provide the nature of why they are opposing the other party's case, as well as the ground in which that opposition is based. And another thing that will align with this principle is that both parties will then be afforded a chance to present their respective cases to court. So the audipartem rule basically ensures that there is equal opportunity that is given to the parties in dispute to present their respective cases to court. Then the third one is that the decision to defend or institute an action and to determine the scope of dispute will rest on the parties. And also, the parties in so doing will decide the evidentiary material that they want to present before court for their respective cases. So for example, if A and B are in a car accident and B is saying, I had a right of way, I bumped you because the robot was green for me, and basically you decided that you are going to pass even though the robot is red for you, so I am not really in the wrong even though I bumped you. And then A will be like, no, but the robot was actually green for me. So in that instance, they'll maybe provide things like your sketches, and if there was any cars that saw the accident, then any other parties that saw the accident, then those parties would form as witnesses in that particular case. So that's what the evidentiary material speaks about. It also says that, so during this is the fourth one, it says that during the presentation of the parties' respective cases, provision will be made for direct oral communication between the parties and the court. However, it does not exclude the possibility that important elements of the presentation, such as any type of evidentiary material, may be in writing. What this means is that if you have a sketch which is going to form part of your evidentiary material, you can actually present it before court. It is going to be in writing. If you're going to draw lines to say this is where A was and this is where B was, and as B, this was my robot and it was showing green for me, and it was showing read for A, that evidentiary material can actually be before court in writing. And also the main proceedings, which can take place through a trial or hearing application, in principle must take place in public. That would mainly be the fifth one, I think. And the sixth one is that the court must consider the evidentiary material on objective and rational grounds. So we do know that judicial officers or presiding officers have to be impartial and independent, and when they are analyzing the evidentiary material that is provided before them, they have to analyze this evidentiary material in an objective and rational manner. So this means that they move away from the personal views of the case and make it more of what does the law say about this particular scenario, and that analysis goes through a objective and rational ground. Then the seventh and eighth one, which is actually the last ones, is that the court has to give a well-reasoned and legally motivated judgment expeditiously. So this means that judgments must be given in or within a reasonable duration of time. Additionally, which is basically the most important part of it all, is that the decision of the court is final and binding. And obviously there are other provisions that are available, like appeals and reviews, and I will obviously discuss that as time continues. The final one, which is bringing us to the end of this tutorial, is the sources of the law of civil procedure. In South Africa, the most important legislation or legislative sources of civil procedure are the Constitution of the Republic of South Africa and the Superior Courts Act, the rules of the Supreme Court of Appeal, the Uniform Rules of Court applicable in High Court, the Magistrates Courts Act, the Magistrate Courts Rules, the Small Courts Act, as well as the common law underlying rules of procedure and jurisdiction of the High Court. Additionally to that, there are other legislations or regulations relevant to specialized courts which may be applicable in the law of civil procedure. There are also other practical amendments and directives in relations to the respective courses of the High Court, which may also be applicable. For example, in Johannesburg High Court, you will have the practice directives that you will sometimes have to look at as it pertains to how you draft certain things, how you do certain things, or the amount of time or duration that you'll have to bring in a certain application. So for example, when you're dealing with urgent applications in the Johannesburg High Court, you'll find that in the practice directives, they tell you that you have to file your papers on a Thursday. That will be the last day for you to file. And then Tuesday, your matter will then be heard on a agent basis. So additionally to that, before I forget, another source that I'm forgetting about is case law. So those are the sources of the law of civil procedure. Thank you guys for watching, and thank you guys for tuning in to my channel here on YouTube. Please kindly subscribe and share it with other people who may find this channel to be helpful. And also for educational and entertainment purposes, please also still subscribe. Next week we will be covering jurisdiction, which I think will basically be the commencement of the actual tutorials of civil procedure, since this was mainly an introduction. I really hope it was helpful. If you guys have got any questions, please comment down below and kindly like and share the video. I will see you guys in my next videos. Have a lovely one. Bye. See you next time. Till I see you next time.